May it please the Court. Good morning. My name is Alexander Dennison on behalf of the appellant, Mr. Howell. This case revolves around my client's right and his real property. The action below was brought with two counts, one to quiet title to the property and one for declaratory relief. As stated in the complaint, my client was without knowledge as to the specific rights still possessed by the other lien holders in the property. What I would like to address is the primary lien holder, what I'll refer to as the first mortgage holder in this case. And I'd kind of like to start at the end, and if I may reserve 5 minutes for rebuttal.
Sure.
Your Honor. Thank you. And by the end, I mean with the statute of repose. The statute of limitations issue, which I addressed at length in the brief, relying on a wide variety of case law from across the country, has recently been addressed by the 3rd District. There's been a notice of supplemental authority filed in this case, and I think that the court in Beauvier addressed the statute of limitations issue very completely. And so I would like to focus my argument on the statute of repose, because I think that there was a detail that was overlooked by the court in Beauvier that I would like to draw Your Honor's attention to. And that is in the plain language of Florida's statute of repose. The 3rd DCA ruled, when addressing the statute of repose, that the maturity date on the mortgage was discernible from the record, and I would argue that that was incorrect. And here's why. In the statute, there are two distinct phrases that are used. The first one describes the final maturity date. This describes a date that is fixed, and it's fixed by the date printed on the recorded document. We can use an example of after a 30-year term, the final maturity date may be in the year 2040, 2035, what have you. The other term used in the statute is the maturity date. Now, this term is a variable, and it's a variable when there's an acceleration clause in a mortgage. If there's no acceleration clause, the final maturity date is the maturity date, because we don't have the ability under the terms of the mortgage to accelerate that maturity date. But when there is an acceleration clause, the date of maturity is always going to be based on whether or not the right to accelerate was invoked. That can never be determined from the record. And this is where I think that a plain language analysis is vital here. And I just would like to walk through that with the court just briefly. The duration of the mortgage lien discussion in Beauvier began on page 23 of their opinion. And I appreciate the court's very detailed analysis, but I think that this distinction that was overlooked is vital to understanding how the language of this statute was intended. Now, this is a classic case where a footnote would have done us all huge service. But the final maturity is always going to be ascertainable from the record when there's a final maturity date printed on the recorded mortgage, as stated previously. But the date of maturity is, again, the variable where when I elect to accelerate as my remedy for a breach of the contract, all of those remaining payments are advanced to that date of the demand. And the plain language of the statute says that when the final maturity date is ascertainable from the record of the mortgage, that the statute of repose runs for 5 years from the date of maturity. So in order to determine the date of maturity, we have to determine whether or not acceleration was invoked, when that date was, so we can start the clock for 5 years.
But I'm not aware that any court decision supports what you're saying. And instead, court decisions repeatedly have said that any event of failure to make payment is again a new opportunity for the lender to accelerate and seek foreclosure. I also, in this case, there are two mortgages, and you seem to only address the first mortgage in everything that you've said. Am I correct in that?
Yes, Your Honor, because I was unable to find whether or not the right to accelerate had been invoked as to the second mortgage.
Okay.
So that was something, we didn't make it to the discovery phase. This case, as you know, was resolved by the court granting an order of dismissal with prejudice based on the understanding, which was, as you said, Your Honor, that the subsequent defaults create a cause of action or create the right to accelerate.
So point me to cases that support your position, because I wasn't clear from your brief that there was support for what you were saying.
The biggest one, Your Honor, is the new one from the 3rd District called the Deutsche Bank versus Harry Belvier. And I'm not sure if Your Honor's had an opportunity to review this case. The analysis of the statute of limitations issue tracks the analysis in my brief, and the court came to the same conclusion that I have, that once acceleration is invoked, there's no mechanism under the law to undo that notice and provide an opportunity to accelerate again. The way to think about this is, if acceleration occurs, it's kind of like becoming pregnant. In order to become pregnant again, something has to happen in order for that pregnancy to end so another one can take place. Now, there's no mechanism under the law that I'm aware of in Florida that would allow for the termination of this acceleration that would give someone the right to invoke that remedy again. And in my brief, I cited an example as arguendo that perhaps if a court ruled that the acceleration was done improperly, for example, they hadn't...
Ineffective.
It was ineffective, Your Honor. Yes, so it was void, if you will, ab initio, so that the right, in effect, had never been exercised. But the case law cited in the brief from all over the country, and the Belvier conclusion in their ruling agreeing with that case law, is that once acceleration occurs, absent some type of notice rescinding that acceleration, which again, I'm not arguing that this court should create such a rule, because I don't think that that's the way that this mechanism was designed to begin with. Once acceleration was invoked, the statute of limitations and the statute of repose were designed to begin running then. And there's some dicta in various cases that I cited that that goes to the point of whether or not it would be appropriate for a party to sleep on their right to accelerate for an extended period of time, thereby extending the amount of time during which they had to enforce their rights under the instruments. But I want to focus squarely on this statute of repose issue.
Before you go there, may I ask you a question about Beauvais?
Yes.
Judge Eames writing for majority on the statute of limitations. Let's assume for the purpose of my question that that analysis is correct. Does that, under the quiet title, resolve all issues that might occur? Recollection suggests that under mortgages there are different obligations to maintain insurance, to do certain things. One of those could also subsequently breach and allow for perhaps a default or a foreclosure, arguably. I understand perhaps then differently on a DEC action to declare your rights. So I'm wondering, with a dismissal, assuming that's correct, would this, if the acceleration statute is run, still allow you to recover under a quiet title action when the note and mortgage has other obligations that your client must perform and they could arguably default in the future?
Well, getting to the contractual analysis, Your Honor, I think that the only remedy provided in the documents is acceleration and foreclosure. Okay. So once that has been exercised, what remedies are left? If there are subsequent breaches, I would argue, of course, there may be subsequent breaches like Your Honor stated, but the remedy's already been exercised. We don't have a mechanism in the documents that provides for additional accelerations and foreclosures every time there may be a subsequent breach. So the enforcement of the obligation has already been exercised, or the attempted enforcement of the obligation. Getting back to Your Honor's question about whether or not the case law supports this proposition, I think is instructive as to the challenges we faced at the trial court making this argument. But the Bouvier court is correct, based on my review, extensive review of the case law around the country and the history behind this area of law, this notion of accelerating remaining payments so that you can call the entire balance due, terminating the installment nature of the contract so that, in essence, one payment is due, which allows you, upon the failure of a party to make that payment, to exercise your remedy of foreclosure rather than just sue for the individual.
But you have to go outside of Florida to find the support you're looking for.
Well, we can now, thanks to the 3rd District, stay in Florida. And obviously, had we had that decision prior to the briefs being filed in this case, Your Honor, my brief would have looked a lot different. But the Bouvier decision speaks directly to that point. They made it very clear in no uncertain terms that once that bell is rung, that acceleration has been invoked, you can't unring that bell. The issue that I have with the Bouvier decision relates to their analysis under the statute of frauds. The statute of repose, excuse me. And again, I wanted to make sure that my point was clear, because I think that this is, in the analysis of the statute, the part that gets overlooked. So if I may just restate that. The first section says that the final maturity date of the mortgage, if it's ascertainable, that is something we're going to be able to find of record. But the maturity date of the mortgage, where the Bouvier court reached the conclusion that they were one and the same thing, that the final maturity date was the maturity date. But the language the drafters used does not reflect that. They used two distinct terms. They used final maturity date, and then they used the date of maturity. And again, I suggest to you that the final maturity date is the fixed date on the mortgage document itself. The date of maturity can only be determined. It's a fact issue. It can only be determined if we can identify whether or not acceleration took place. Now, that can take place, as it did in our case, of record by the filing of the complaint in the prior foreclosure action. In the complaint, the plaintiff stated, "We hereby accelerate all sums due and owing." Now, more than likely, upon discovery, we would find that, as is the common practice, a letter went out from the lender to the borrower stating that, we call it a 30-day letter, that this is your notice, that you're in default. We're exercising our right to accelerate if you don't pay us within 30 days by this date. And that's the common procedure in these cases. So acceleration more than likely occurred sometime prior to the filing of this action, but it occurred no later than the filing of the action. And based on the statute of limitations running, because there were no subsequent payments due, there were no remedies available under the contract left for the lender to invoke, the statute of repose also has run. Because, again, the language in the statute of repose uses those terms, fixed maturity date and date of maturity. And while the 3rd District, I think, wanted to interpret the statute in a way that would allow them the opportunity to review the record to determine the date of maturity, that's simply not possible because of this notion of acceleration. When there's a contract that does not have an acceleration clause, that would be the case. The date of maturity would be the final maturity date on the mortgage. But because the Fannie and Freddie uniform instruments that are used in modern commerce all have an acceleration clause, the analysis is going to be one that requires us looking outside of the recorded instrument to determine if a party accelerated. Now, there would be additional issues of fact there. Did the party that accelerated have the right to do so, for example? Can they demonstrate that it was done properly? So understandably, it's not as clean-cut a process determining these timeframes as the third district explained in their opinion. Excuse me.
You're coming down to 5 minutes left.
Oh, thank you, Your Honor. With that, I'll reserve the remaining time for rebuttal.
Okay, thank you.
Good morning, Your Honors, and may it please the Court. Your Honors, I represent three appellees in this case: U.S. Bank, SunTrust Bank, and Mortgage Electronic Registration Systems, commonly known as MERS. My name is Christian Ledger with the law firm of Gray Robinson. Just to address a housekeeping matter, the first mortgage in this particular case is held by U.S. Bank, the second mortgage by SunTrust Bank, and I may refer to those by the party holding them. Your Honors, this is not a case where a statute of limitations has been raised as an affirmative defense to a foreclosure action. This is a case where a borrower has gone into the courthouse and has filed an affirmative action to quiet title seeking to invalidate a lien based upon a default that occurred more than 5 years prior. So resolution of this particular case involves really a two-step analysis. The first step is to answer the question of whether or not a borrower has the right to use the statute of limitations in an affirmative manner to terminate a lien. And under the relevant case law, particularly this Court's decision in Hoke versus New River Limited Pasco, the answer to that question is simply no. The borrower cannot affirmatively use the statute of limitations in that manner. The second question is whether or not the statute of limitations bars a subsequent foreclosure 5 years after an initial acceleration. But the Court need only reach that initial question if and only if it decides that the borrower can affirmatively use the statute of limitations to terminate the lien. And we would submit, Your Honors, that the answer to that question is no, because as has already been noted, every event of default presents a new and separate right in the mortgagee to accelerate the loan and bring a foreclosure action based upon that new default.
Files their lawsuit, fails to prosecute it, lets the statute of limitations run, what other debt can they reaccelerate? If the letter says the entire principal balance is now due and owing, what other sums can be due analytically?
Your Honor, this payments that continue to come due on the installment contract, and I think the answer to your question really...
I didn't mean to interrupt you, but I have a question that follows on that.
Absolutely, Your Honor. Really stands in the analysis of the Florida Supreme Court's rejection in Singleton of the Stadler opinion. In Stadler, the Florida Supreme Court noted that the Stadler court had taken the stricter and more technical view of acceleration, which was that once a debt was accelerated once, it could never be accelerated again, and that all subsequent payments were placed at issue. And the Florida Supreme Court rejected that analysis and went with a much more liberal approach, which said that each subsequent event of default presents a new opportunity to accelerate. So to answer your question, it's the same debt, but it can be accelerated more than once.
So if we follow that, then that would mean that if they default on payment January 1 and you accelerate, when they send you a check for February 1, you have to take it?
There are other provisions of the mortgage that deal with whether the bank has the discretion to accept those particular.
So what you're saying is it really is totally accelerated because the bank's not going to exercise their discretion to take a partial payment or a 1-month payment for the rest of the balance, right? If they've already accelerated. In the real world, you're saying it's really done, and you're going to exercise the other prerogative, say, oh, we accelerated, we don't have to take your payments because everything is now due.
Yes, Your Honor, that discretion is reserved to the mortgagee under the mortgage.
Then he started to get into my question.
Sorry.
If the acceleration, the initial acceleration occurred after year 10 in a 30-year mortgage, could you do that for 20 years and then foreclose? Reject the payment every month for 20 years?
Yes, Your Honor, you would be able to, because each occurrence of...
They tendered a payment. You accelerate after year 10, and then but for every month thereafter, the mortgagor tendered the monthly payment lender rejects it because the whole amount's due. Could you do that for 20 years and then foreclose?
Your Honor, you would be able to do that because, again, under the contractual terms of the mortgage, it reserves the right to the lender to accept payments. However,
but the lender has not accepted the payments, is the point. And so they have accelerated based on a default after year 10. And then under your argument, it would seem to be that then after year 30, they could go ahead and foreclose based on the default in year 10.
Absolutely, Your Honor, because, again, they reserve that right under the mortgage whether or not they can accept the payment at that time. However, what's truly important to note in analyzing these issues is that
when, though, is the foreclosure in relation to that default?
The foreclosure would be based upon what is alleged in the complaint to be the dates of default, because the Florida Supreme Court has held that
20
alleging...
years before. In my hypothetical, 20 years before there's been a default.
No, Your Honor. You would only be able to allege defaults occurring within the limitations period.
Right.
So therefore, if you defaulted in year 10, the foreclosure was brought in year 30, in Your Honor's example, the default that's alleged would have to be alleged sometime within the previous 5 years, because defaults that are outside the limitations period could be barred under a statute of limitations analysis. And therefore, the lender would have to say, I'm alleging a default in years 25 through 30, could not allege a default that occurred more than 5 years prior, which is why each new default occurring within the limitations period is what creates a brand new cause of action. For example, Your Honor noted, there are other obligations in the mortgage, insurance, taxes, due on sale clause. If at any point in time those obligations become breached as well, it creates a new and independent right in the mortgagee, separate and apart from any alleged payment default that might be previously raised. It creates a new right to accelerate the full balance that is due and owing under the note and mortgage and bring a foreclosure action. But again, Your Honors, returning to the two-step analysis that's at issue here, the court need not resolve this question in this case, because really what we're dealing here is not a borrower who's raised the statute of limitations as an affirmative defense to a foreclosure action. What we have here is an attempt to use the statute of limitations offensively against the bank.
Or the statute of repose.
Or the statute of repose.
Which, you know, I could see why someone would want to do that. If their property is encumbered, they don't know, you know, can they sell it? What's it worth? What would a buyer, you know, I mean, there's a lien on it. And why wouldn't a buyer want to, a borrower want to know whether that's still enforceable?
Your Honor, I can certainly...
That seems to me to be a legitimate inquiry.
I can understand absolutely why a borrower would want to know that.
Whether in the context of an affirmative defense or otherwise.
Yes, Your Honor. But the statute of limitation can't be used affirmatively. Essentially, turning to this court's decision in Hoke versus New River Limited Pasco, the court explicitly noted that the limitations period provided in section 9511, which is exactly what we're dealing with in this particular case, does not affect the life of the lien or extinguish the debt. It merely precludes an action to collect the debt after 5 years. And at most, what the borrower could obtain...
Well, that's different from, you know, so that, you know, that would apply to the quiet title action.
Yes, Your Honor.
The deck action would say, listen, is this enforceable?
The deck action would present an entirely different issue, because there you would essentially be asking for an advisory opinion of whether or not, if the bank were to foreclose in the future, I would have a valid affirmative defense of the statute of limitations. And that limitation on the jurisdiction for a declaratory judgment action really limits the borrower severely in their ability to walk into the court and seek that kind of advisory relief with respect to the statute of limitations or the statute of repose. And turning to the statute of repose, what the appellant has essentially asked this court to do in this case is merge the statute of limitations analysis and the statute of repose analysis. And the Beauvais decision addressed this directly. And what's interesting is that opposing counsel has relied on the plain language, but Beauvais itself relied on the plain language of the statute in reaching the exact opposite conclusion. And there the statute plainly says that we have to look at the ascertainable date from the record of the mortgage. And in looking at that, it says if the date's ascertainable, we simply add 5 years to that date, and that's the statute of repose date. And as Your Honor noted, there's no basis in the law to shift the date of the statute of repose based upon whether a statute of limitations has occurred or a statute of limitations has not occurred. Here we have a 2007 mortgage. The 2007 mortgage matures in 2037, so we would add 5 years to that, and the statute of repose would occur in 2042. Only at that point would a quiet title action or some sort of affirmative relief be available by a borrower in an action against the bank. Furthermore, Your Honor, the Hoke opinion expressly noted that even though in that case there was no acceleration, it was a final balloon payment due at the end of the note, and the court noted that even though the balloon payment had come due 5 years earlier and the statute of limitations barred that particular payment, the due on sale clause and other clauses of the mortgage still survive. And therefore, the statute of limitations cannot be used in an offensive manner, such as the appellant attempts to do in this case, for the purpose of terminating SunTrust lien. And in fact, SunTrust has a foreclosure, excuse me, not SunTrust, U.S. Bank has a foreclosure action pending based upon a default under the provision to pay taxes, which is a separate and independent clause of the mortgage. And opposing counsel has noticed the court of the pendency of that related action. Moreover, moving to the second issue, only if the court finds that they can raise this in an offensive affirmative fashion do we have to reach the issue of whether the statute of limitations can bar a subsequent foreclosure action where there was a prior acceleration more than 5 years ago. And I think it's fairly well accepted that that turns on analysis of the Florida Supreme Court's decision in the Singleton v. Graymar case from 2004. And what the court held in that particular case initially was it resolved the circuit split between the Stadler decision and the lower court in Singleton. It first rejected the stricter view of acceleration held in Stadler, which was that once you accelerate, that acceleration is final and is res judicata on any action after that's dismissed with prejudice. That strict technical view of acceleration espoused in Stadler was rejected by the Florida Supreme Court. The court then goes on to analyze the nature of acceleration and notes that every event of default presents a new right to accelerate and a new right to bring a mortgage foreclosure action based upon that acceleration. Because you have a new right and a new action, res judicata doesn't apply. What Beauvais does, the decision that grapples with Singleton a little bit, is it flips that analysis on its head. Singleton says, because you can accelerate more than once, res judicata does not apply. Beauvais flips that and says that we have to look at res judicata principles before we can determine whether you accelerate a second time. That frankly gets the cart before the horse in the reading of Singleton from the front to the end. And the first decision...
That Singleton, as you say, Supreme Court, there are multiple possibilities of default. Can you reconcile Singleton with the third district saying the statute of limitations has run on the claim that you raised, that is, acceleration due to fail the monthly payments, but the mortgage still exists because there's possibility of other defaults, there's not res judicata on those, and therefore the quiet title action may still be denied because you still have a valid lien. Because, as you say, insurance, taxes, and all those other things could still rise in a default.
If I understand, Your Honor.
Proper reconciliation of those two cases?
Your Honor, you could reconcile them that way. However, the court has also noted that there's the ongoing relationship between the borrower and the mortgagee in that particular context. And what's important to notice is in Singleton, what creates the new cause of action, the court says, is the allegation of a different period of default. Therefore, when the court says that by alleging a different period of default, see, let me get the language right here. The subsequent and separate alleged default created a new and independent right in the mortgagee to accelerate payment on the note and a subsequent foreclosure action. Therefore, when the mortgagee comes in the subsequent foreclosure action and alleges a different set of defaults, it completely refreshes the right to accelerate and file that subsequent foreclosure action. And that's exactly what the 5th District picked up on in the Bartram decision when it said that if a new and independent right to accelerate exists in a res judicata analysis, there's no reason it would not also exist vis-a-vis a statute of limitations issue. A new and right to accelerate would have to mean that the new defaults presented new causes of action regardless of the fact that their dates had been accelerated in a prior suit. And that's really the crux of this issue, is that the subsequent defaults create a brand new right and a brand new cause of action. And
assuming that to be true, you have a 30-year, under Judge Northcutt's hypothesis of mortgage payments, and you go to year 10, and they say there's been a default for the last number of years. And then you accelerate on that. The statute of limitations, let's say the 3rd District is correct. 5 years has expired. Does that mean that period for which you could have brought suit from 0 to 10 is now barred, but the other defaults from year 10 forward are not?
That's right, Your Honor. And the case law states that under such installment contracts, the limitations period may bar an action on some payments, but not an action on other payments. And therefore, you can bring a foreclosure action based upon defaults that are occurring within the limitations period. Now, that default still gives you the right to accelerate, of course, the full balance that's due and owing under the note and mortgage. And that's exactly what Singleton noted when it held that the subsequent and separate alleged default created a new and independent right to foreclose. However, as I mentioned, the Beauvais decision flips that on its head. Singleton says, because you can accelerate a second time, you have a new cause of action, and therefore res judicata doesn't apply. Beauvais asked the court to look at res judicata first, which is the exact opposite of what Singleton did. And if I could, Your Honors, I'd like to respond briefly to a few arguments made by opposing counsel.
We have about 4 minutes left.
Thank you, Your Honor. The first item I'd like to respond to is the notion that paragraph 22 only provides the remedy of one acceleration, that once you have accelerated, the bell has, as opposing counsel phrased it, been rung and it cannot be unrung. And Your Honors, that's simply contrary to the express language of Singleton, which, again, rejected the notion from Stadler that the bell must be rung once and can never be unrung. Each default creates a new cause of action. Additionally, as I mentioned earlier, the statute of repose, by its plain language, says that it's what's discernible from the record. If you can discern the date of maturity from the record, you add 5 years to that, and that establishes, for all purposes, the statute of repose on a mortgage. If it's not discernible from the record, 20 years establishes, for all purpose, the date of the statute of repose. And there's no authority in Florida or outside this jurisdiction for the notion that acceleration would in any way affect the final date for a statute of repose. And finally, Your Honors, I'd like to note that this is also a motion to dismiss analysis that we're dealing with here. Opposing counsel has never claimed that there were additional facts that could be alleged that would support his cause of action, or that he should have been given the right to amend by the lower court. He has simply argued in his brief, that the complaint, as stated, states a cause of action. And that complaint only says that the prior default was declared on the first mortgage, makes no allegations with respect to the second mortgage, and then says that that statute of limitations should completely extinguish the mortgage at issue. And under the case law, a statute of limitations cannot be used offensively to terminate a mortgage lien in the manner under a quiet title action such as opposing counsel and the appellant are attempting to do it here. Therefore, Your Honor, we would ask this court to affirm the lower court's decision dismissing the quiet title complaint with prejudice. Thank you.
Mr. Thomason.
May it please the court. Florida Statute 95.281(1)A states, if the final maturity of an obligation secured by a mortgage is ascertainable from the record of it, comma, 5 years after the date of maturity. That's the point that I'm making with regards to the plain language of the statute. They could have simply said 5 years after the date of final maturity. They did not. They said 5 years after the date of maturity. The Bouvier Court did a thorough analysis of Single and Stadler and the issue of res judicata. The point that I want the court to understand is that that analysis did say that if there were subsequent payments due, that would generate a new cause of action. The reason for that is the cases were dismissed with prejudice. That's an adjudication on the merits. That's the exact example that I gave as a hypothetical earlier in the argument, that if a court determined that acceleration was ineffective, that it was ineffective. That's Singleton, that's Sadler. There's a very thorough analysis in Bouvier that deals with that issue directly. In this case, we don't have an adjudication on the merits. We have a party who slept on their rights. In regards to seeking an advisory opinion, that's not the case at all. There's a clear disagreement in this case among the parties about the rights that they have to the property. That's indicated by the additional foreclosure case that was filed subsequent to the filing of this action. Clearly, the parties have a real adverse disagreement as to the rights, and therefore a declaratory judgment would be absolutely appropriate. There's nowhere that states that you simply add 5 years to the final maturity date. Again, going back to the statute, it's 5 years after the date of maturity. There's a clear distinction there between a final maturity date and a date of maturity. The clauses survive was an argument that counsel made, and again, we addressed this earlier. There may be additional opportunities for breach in any number of contracts, but how many times do we get to exercise remedy? That's determined by the contract and by Florida law, and I believe we've already addressed that. The idea that a new right is established with each subsequent breach following an acceleration is an erroneous statement of the law. The law is very clear. Acceleration advances the maturity date. If the maturity date is advanced, it's advanced for all purposes. There's nowhere in the law that says it's advanced for this reason and it's not advanced for this reason, or it's advanced for this reason but it's inconvenient if it's advanced for this reason. It simply says that acceleration advances the maturity date. Previously, I stated that the bell can be unrung, right? Something to that effect. And that is the analogy I believe I got from the Arizona court, one of the courts, excuse me if it wasn't them, where conceivably the court or legislatures could fashion a mechanism, a clear bright line rule that says in these circumstances we're going to allow somebody to unwind the effects of acceleration for all purposes and allow them to do it over. We don't have such a rule. But arguably in Singleton and Sadler, the courts found such circumstances where the acceleration was ineffective. For res judicata purposes, they said that the subsequent defaults would not be barred. That has nothing to do with the statute of limitations. It has nothing to do with the statute of repose. It is merely a res judicata analysis. So Bouvier is not in conflict with Singleton and Sadler. Bouvier is analyzing the statute of limitations in a way that we have not had in Florida courts. The analysis for the statute of repose is designed in a manner to mirror the statute of limitations when there's an acceleration clause in the documents. The difference could be when there's not an acceleration clause. If you had a pure installment contract that did not give the party a right to accelerate, obviously the default could occur on year 10. The final maturity date would be in year 30, arguably. When there's an acceleration in play, that is simply not the case.
Okay, Mr. Dennison, you need to wrap up.
Thank you, Your Honor. For the foregoing reasons, I understand that this is an area that hasn't had a lot of treatment in Florida courts. I appreciate the opportunity to be here to make this argument. appellant would ask that the judgment below dismissing the complaint with prejudice be overturned because the statute of repose has run. The statute of limitations has obviously run under Beauvier, but because of that, we're not asking for anything to be terminated. We're not asking for, I forget the other term counsel used, we're simply acknowledging that the documents are what they are and that the right to enforce them has ceased to exist. Thank you.
Thank you.